when our clients come to us, they want to make sure that what they've worked their whole lives for isn't used to just drain everything to go to a nursing home. They want to protect it for the family. And that's what this attorney didn't do. Hi, Jeff Marsachi, the Plain English Attorney, and welcome to the video. Today, we are going to talk about long term vision when it comes to Medicaid planning and how a lot of Medicaid planning attorneys end up falling short. This is an extremely unfortunate thing that I'm seeing in my industry. The bar is really set kind of low with what the families are expecting to happen versus the reality of what is out there and what is being offered. Now, the whole thing is these attorneys are also not violating any kind of rules. They're not failing to meet standards because, yeah, that bar is set so low that what they're doing is considered, well, this is the way it's done. And so there isn't any real negligence on their part. They're just not doing nearly as much as they could, and not nearly as much as what I do with my law firm and with the Care Assistance Center that we put together. We are really looking at everything in a comprehensive way and thinking several steps ahead. And that's the big key that's not happening. They're not thinking several steps ahead. They're only looking right to the tip of their nose. And what do we need to do for our client? Oh, we just need them to get qualified for Medicaid. They don't think about the other protections for the family down the road.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Right. So let's use an example that's kind of going on right now. We had some clients, they came to me, and this is what happened with mom and dad. Dad passed on. There was an attorney who helped get things set up for Medicaid planning a long, long time ago. And now we're starting to see just how the bare minimum was done. All right. What is the so we got five things where Medicaid planning attorneys in particular, or Medicaid planners in general, are falling short. And the first one is not having any contingencies in the power of attorney documents. All right, so we have a power of attorney and a healthcare power of attorney. This is one of the standard things to make sure that if you've got a couple, that the other spouse is able to handle and make decisions. Now, this is a pretty alarming statistic that I've found. And 60% of the time, when you have a couple and one of them needs long term care, 60% of the time, the caretaker spouse is the one who passes on first. All right, 60% of the time. And I'm seeing this when it comes to Medicaid planning. I'm not necessarily seeing the same thing, or at least with the same frequency with estate planning. There's no contingent agents listed in those documents. And in this case, that was it. There were no contingencies listed. Okay. So here we have mom in the facility. There is no backup, there is nothing else listed. So now there is no power of attorney now that dad has passed on. Now, fortunately, mom is still able to execute a power of attorney, still able to handle things and put together a new one, but it shouldn't have had to be this way. There should have been multiple contingencies listed. In particular, the son who's now picking up the pieces and having to take care of mom, he's the one who should be that power of attorney. All right, so that's the first thing. There were no contingencies. It really should be built in to have a lot of contingencies. Second thing, and we saw this when we looked at the deed. Mom and dad are both on the deed. Okay, here's a couple of things you may or may not know. And unfortunately, there's a community leader in another city that was very adamant, you can't keep your house and get Medicaid. Well, yeah, you can up to a certain equity limit. If it's a husband and wife, yeah, they get to keep the house. If it's an individual, they get to keep the house. I'm going to quote this number. I'm pretty sure it's right. This is North Carolina. You can keep that house, still qualify for nursing home Medicaid. and have up to 713, 714,000. Not exactly sure which. You can look it up. You can have that level of equity in a house, and it's still not going to get in the way of you qualifying for Medicaid. You get to keep that primary residence as long as you have even a subjective intent to return home. And you always have that subjective intent. People want to return home. All right. So, why is it still listed in mom and dad's name when a transfer between spouses isn't something that's going to cause any kind of penalty period or gift on the part of Medicaid? Why didn't they move this house over to dad? That would have been one step. Second step would have been dad could have taken it and moved it into an irrevocable property trust. And then, as long as he didn't need care 5 years later, it would have been off the table. Because this is the thing that a lot of people don't know. And if they just go to the Medicaid office for answers, this is what they'll tell. Oh, yeah, you can keep the house. The equity limit's fine. Medicaid can come back and put a lien against the house. Now, if mom had gone first, dad would have inherited the house automatically based on that old deed. But in this case, in 60% of the cases, dad is the one who passed on first, and now the house is in mom's name. Medicaid can put a lien against the house. So we have to address that issue and find a way to pull that out so that it's not going to end up getting lost to the nurse, to quote, lost to the nursing home, but really lost to Medicaid. When our clients come to us, they want to make sure that what they've worked their whole lives for isn't used to just drain everything to go to a nursing home. They want to protect it for the family. And that's what this attorney didn't do. They didn't look anywhere beyond getting their client qualified. They didn't look to what the client wanted, which is to make sure the house stayed within the family and all that work wasn't lost. So that's what we have, and that's what we have to deal with. Third big thing is not doing any documents for the other spouse. So when a spouse goes into a nursing home, the other spouse is outside the nursing home, they need to have documents put together as well, particularly a healthcare power of attorney and a financial power of attorney. The estate plan kind of needs to be redone to now account for the fact that mom is in the nursing home. She can't be a beneficiary. We have to set things up, and there's no absolute immunity from dad potentially getting sick down the road and needing someone else to step in. So not only do we need contingencies for mom who's in the nursing home, we also need to put in that with dad's documents that it's not mom who's in charge, it's somebody else, and have contingencies built in. So that's the third big thing. Fourth big thing, and this is another thing that just happened in this case. There were these old wills. They were never redone, and dad listed mom as the full beneficiary in his last will and testament. So now anything that ends up in probate is going directly to mom using some of this old language, free and clear of any trust. So as if anything ends up in probate and it goes to mom and it pushes her over that $2,000 limit, she's going to get kicked off of Medicaid until she spends all that money down. So this was another complete failure, not redoing dad's plan and dad's will to make sure we're accounting to protect mom. The other thing is there were beneficiary designations, and this Medicaid planning attorney probably did, I can't say for sure, advised him because he put mom is getting a third, son is getting a third, daughter is getting a third. Well, still, that's a third going to mom. That's going to end up disqualifying her if any of that ends up going and pushing her over the $2,000 limit. So, what should have been done is that anything for dad's estate should have either been held up or gone to a trust to make sure that she's taken care of outside of what Medicaid's planning, pay for all the extras. We could have set up that estate, and we frequently do set things up this way, so that as soon as mom's qualified, dad redoes his whole plan. So now his assets are off the table. If anything happens to him, which again does happen about 60% of the time, they go first. So that fourth thing is making sure that dad's taken care of. Now, the fifth thing, this is just kind of incorporating all of this. It's setting up the actual Medicaid planning toolbox. In all but the simplest of cases, usually it's when there isn't a spouse. Okay, maybe we can adjust things, spend things, move and shift money here and there. There's not a lot there. Okay, you can end up getting qualified. But if not, we're doing and setting up the full Medicaid planning toolbox, which is several trusts, the two big ones being an irrevocable property trust, an irrevocable family trust to contain the money, work and do a financial game plan to get the money into the trust in the most advantageous way. I'm not going to get too deeply into that. For that, you can go and check out my the free course we have, freemedicaidcourse.com, and it'll run through the different rules. And there's a couple of examples of different techniques and some of the webinars in that course that we have also out there. It will run through these different scenarios. There are so many different rules that we can take advantage of and use to leverage a really good plan that's comprehensive, but having at least those two trusts as part of the toolbox that we're setting up just makes sense. There's also an irrevocable funeral trust, special needs Miller trust, and all of those power of attorney and other and last will and testament and other planning documents that become part of it. And if it's for a couple, we're doing it for both husband and wife. Oh, well, we don't need this trust because they don't have any real estate. Yeah, but if there's money in the irrevocable family trust and a real estate investment opportunity is coming up that the trust can take advantage of, we could shift money from the family trust to the property trust, purchase the property, and now there are some specific tax advantages for the family down the road. Again, thinking several steps ahead. If you don't have that trust already in place, then you can't do that. Or if you do it within the irrevocable family trust, it's going to have a pretty negative potential tax impact once mom and dad have both passed on. So it's there. We also do an irrevocable funeral trust, but don't put any money in it. Well, then why do we need it? We don't need this trust. Let's just not do it. No, 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 no. This is the place where you can put up to $10,000 to handle funeral and other expenses if you need to shift money around for either mom, in this case, is the one who needs care, or if dad needs care down the road. Okay, we've got it there. If we need to do a quick spend down at the last minute, putting some money there and having that option just makes sense. You want the full toolbox in place if what you have and what you own is at a level where, yeah, we might need to make some of these moves to be completely advantageous for the family, the whole family, not just the person being qualified for Medicaid. Right. So these are the five ways that a lot of Medicaid planners in general, and Medicaid planning attorneys are kind of falling short. They're only looking as far ahead as they need to get that particular spouse qualified for Medicaid in the nursing home, and that's it. They're not thinking of the different contingencies. That's what we do to make sure that we're doing a comprehensive plan. It's not just me as an attorney. We have our care team. We also have financial professionals. We need to coordinate with your tax professionals to make sure all of this is done in the most advantageous way, not just for that one client, but for the entire family, because that's what the client wants. Right. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.